So I think it's open here. Okay, welcome. We are going to do what is commonly known or uncommonly known, I don't know, whatever you want to call it, but it is, we're going to take a brief look at a bill that is downstairs in judiciary that is has reference to things that are in our jurisdiction. However, I made the decision that we needed to take possession of the bill. Representative Donahue has been our connection with judiciary, and so she's very familiar with these issues. And so we invited Ledge Counsel and the reporter of the bill, who is going to be Representative Lalonde, I think, and he will be here shortly. So thank you, Eric, for being here. And the floor is yours to give us a walkthrough of this bill.
Sure. Thank you very much. And good afternoon, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, as the chair said, here to give the committee a walkthrough of House Bill number 2, which is an act relating to raising the age for juvenile delinquency proceedings. Bill has not been voted out of House Judiciary yet, but I think the version in front of you, at least last I knew, things can change, but last I knew, this was the version that was going to be voted on possibly tomorrow. But so there's always amendments that could be made, but at least I think it's good to know that the version you're looking at in front of you is pretty close to the final version. So I can give a detailed walkthrough, but also might be helpful before I do that to give a moment of background, just so the committee understands sort of what are the different topics that are being addressed in the bill. Generally speaking, what it's talking about is when a young person commits an offense that would be a criminal offense, if the person were an adult when they commit it and would go to the criminal division of the Superior Court, if the person is not an adult, they're a child when they commit the offense, sometimes the offense doesn't go to the criminal division, it goes to the family division as a juvenile offense, right? So it's that distinction that kind of underlines what's going on in the bill that you're looking at. So the obvious question is, well, what makes a difference, right? How is it that a case can end up either in the family division as a juvenile proceeding or in the criminal division as an adult criminal proceeding? What are the factors that make up the decision about where the case ends up? And there's two factors that always are going to be involved in this. One is, what's the offense? What's the nature of the offense? And the second is, how old is the person? So, and those things are kind of moving parts a little bit, but if you kind of keep that in mind, that will, I think, help understand what the proposals are in the bill. So first of the moving factors that I mentioned, which is what type of offense is it? You may be familiar with the term Big 12. Maybe you've heard that before. It's interestingly no longer the Big 12 as of last year, but for many decades, the Big 12 referred to a list of 12 offenses in Title 33, the juvenile proceeding statute that I think this committee deals with quite a bit, related to Chin's proceedings as well. But there had been this list of 12 offenses, and if one of those, if the child, and at the time anyone essentially aged 14 through 17 committed one of those offenses, one of those Big 12 offenses, case starts in the criminal division. So child, but goes to criminal division if it was a Big 12. Last year, that 12 became 14. So now it's not the Big 12, it's the Big 14, although it didn't add 2, it actually subtracted 1 and added 3. So you end up with 14 as the total number, but it was the math was a little, not quite so straightforward. So it subtracted 1 offense, which was burglary into an occupied dwelling. It added 3 more, which was aggravated stalking, drug trafficking, and using a firearm while committing a felony. So those 3 got added to it. So any one of those, another slight wrinkle though, for the 3 that got added, it's actually only 16 and age 16 and above. So usually the Big 12, or now Big 14, or what had been the Big 12, try and keep those numbers straight, I guess. Big 11 is what it is now. For those first 11 offenses that were part of the original Big 12, it's age 14 and above. So someone commits one of those offenses at age 14 above, starts in the criminal division. For those new 3, it's age 16 and above. That was just a product of legislative compromise. But so that's where you're sitting right now with what sort of offenses end up in the criminal division as of what sort of offenses end up in the family division. Second factor, remember I mentioned, was age. right? Depends how old the person is, and I just sort of mentioned that. So if it's 14 and above for one of those big 11, it starts criminal. If it's 16 and above and one of the other three, it starts criminal as well. So what starts in the family division? Everything else. So it's pretty much those are the distinctions, everything else. So any other felony, that list of 14 offenses are all felonies. So any other felony that's not in that list, and any misdemeanor. If the young person committed any one of those offenses, starts in the family division. Now, in some cases, there can be transfers between the two divisions, but that's not really dealt with so much in the bill that you have in front of you. So I'm not really going to get into that. Unless you want me to, I can.
No.
Right. It's a very intricate process.
We had some overview of that at the first week of the session or second week of the session. And when we got the sort of like full grasp of how complicated this is. So, yeah. I won't say that we understand it all, but we at least have some knowledge that it exists.
That's good. Well, that's good. You have that in the back of your mind at least. Right. Okay. So going to the age piece again, when I said, okay, everything else other than that big 14 starts in the family division. True. But it's not every single young person who is covered by the jurisdiction of the family division. It's age 10, right? It starts at age 10. And goes up through now age 18. And that sort of segues me a little bit into this raise the age topic, which is also going on here. But the point I'm really trying to make there, first of all, is that under current law, the jurisdiction of the family division, and they do that by defining child, is age 10 through 18. So that means, if you think about, so age 10 through 18, child commits any one of those other offenses that I mentioned, right? Any offense that's not a big 14 offense starts in the family division. But let's say it's a 9-year-old, right? Because it's a stage 10 through 18. I'm setting this out there because it's going to transfer you right into hopefully what change is proposed in the bill. But let's say it's a 9-year-old. Can't bring a juvenile proceeding against a 9-year-old. That's not the way the statute is defined. It's not the way the proceeding works. So the fact that a 9-year-old committed that sort of conduct could be relevant in a CHINS proceeding, for example, when the issue is whether the child is beyond the control of their parents or not, or whatever issue might be relevant in a CHINS proceeding. It could be brought in as a factor that the court would consider. And as this committee knows, those are situations where DCF might take custody of a child, things like that. And their behavior is certainly relevant. But if it's below the age of 10, you can't bring a juvenile proceeding against a kid. That's outside of the court's jurisdiction. So that's my end of my background. I can pause for a moment if there's questions, and then I'll go right into, well, what changes to what I just described are proposed in H2? I'll take that silence as
Yes.
we're on board.
Yes.
And, all right.
We're here.
Okay, right. So change number 1, I just mentioned, right? The low age threshold currently under current law is 10. So under age 10, can't bring a juvenile proceeding, but age 10 and 11, you could. If proposed changes, bump that up to 12. That's the first thing you see. I don't know if everybody has a copy. I didn't name it.
We have, it's on our website if you're not looking at it. Yes.
We did have it. Oh, great. Okay, sorry. So yes, that's the first change. That's on page 1, line 13. So it bumps up that low threshold of whether a juvenile proceeding can be brought against a young person. So now, assuming this proposal were law, for example, the proposal is a 10 and 11-year-old who right now could be the subject of a juvenile proceeding would not be able to be under the proposal here. So whatever is the status of, how I mentioned 9-year-old, 8-year-old, 7-year-old, that would become also true for the 10 and 11-year-old. Could be relevant in a CHINS proceeding, could be some other reason that it might come up for DCF, but could not be a juvenile proceeding against a 10 or 11-year-old child for committing one of those non-big 14 offenses. So that's change number 1. Change number.
I feel like my brain did a rewind for a moment.
Yeah.
So I just want to be clear. So so 12 years of age means that they, will you just state it one more time? Because I feel like I need to hear from you one more time.
Yeah, definitely. Right now, the sort of threshold for whether or not a child can be brought into the family division in a juvenile proceeding is age 10. So it's 10 and above, 10, 11, et cetera. So that means 10 and 11-year-old commit, say, shoplifting,
Yeah,
right? It's non-big 14 offense, misdemeanor. They commit shoplifting. It's possible that the 10 or 11-year-old could be brought into the family division and charged with the juvenile act of shoplifting or petty larceny, as technically what we call it. But the proposal is to move that minimum threshold up by 2 years to age 12.
okay.
So same situation, 10-year-old commits shoplifting, could not be the subject of a juvenile proceeding. The fact that the child engaged in that conduct could be relevant in some other DCF proceeding, some CHINS proceeding, for example, but it could not bring a juvenile proceeding against a 10-year or an 11-year. That's because the lower age threshold is moved up by 2 years to age 12.
So then is the result that then those proceedings would be then public?
No, nothing about the nature of the proceedings changes.
Okay.
Just the age threshold.
All right. I'm not sure I totally understand it yet, to be honest, but we'll rely on an additional explanation from. So I want to make sure we get through it all.
Yeah.
Yeah, just to clarify, because I know that this had gone through several iterations, and the only thing I see, if I have the right draft 4.1.
It's 5.1, sorry, but
Oh,
I don't think-
okay, we
I don't-
have 4.1.
Oh, we have 4.1 in our, do you have another draft you can send us?
yes,
Or
'cause-
tell us what's difference.
Four point one, same graphic, just shows stuff that's been struck.
Okay, okay, so-
Clean version of what you're.
oh, yes.
So the only thing that's struck here, there's nothing, I mean, any act of delinquency is changed to 12. But there was but it's striking sub 1, which refers specifically to prior to age 10 could be brought
I
up.
haven't gotten to
Oh,
that
you
yet.
haven't gotten there yet. Okay, I'm sorry.
Yes.
All right, so keep going.
But I'm about to, so thank you for the segue. So I mentioned change 1, that was the age 10 to 12. This is change 2 that Representative Donahue was referring to. So remember, as I said, remember that the general threshold in the law, under current law, is age 10, right? Anything below 10, right, it can't be brought to juvenile proceeding, right? Except there's one exception, and that's murder. That's what your Representative Donahue was just looking at. There's one exception to that. Under current law, if you've committed an act before attaining age 10 that would be murder, then you can be the subject of a delinquency proceeding. So there is that one exception. And that's the second proposed change in H2, which is to strike that. So there would no longer be an exception for murder. The proposal is we're going to treat all children of the same when it comes to whether or not you're going to be in the family division or the criminal division on the basis of that low age threshold. So you bump the age up from 10 to 12, and you simultaneously strike the exception for murder. So all offenses committed by a child under age 12 could not be subject of a juvenile proceeding.
When you keep saying could not be subject of a juvenile proceeding, does that mean they would be subject to an adult proceeding?
No,
Okay,
They couldn't-
that's what I was trying to get, that's where I was being
I see.
confused.
Right.
Okay. So it's,
There's just no proceeding.
They're not, they
No.
can't be charged with a crime.
correct.
Can't be charged with a crime.
okay,
Yeah, that's a better way to put it. Thank you.
Yes.
Sorry for the confusion.
All right.
In any court, right?
Right. Yep, exactly.
that cleared up my confusion.
Yes.
Thank you.
Yes, that makes sense. All right, so that was change number 2. Okay, so this third change, which is over on page 2, this has to do with the other end of the age spectrum, right? So we're talking about the lower threshold now. The upper threshold, which is under current law, in other words, what's the oldest a person could be and be in the family division right now is age 18, right? As of 2020, that was the case. That's sort of brings in the raise the age issue. Up until 2018, the upper age was 70, the 18th birthday, which was age 17. And that is typically the case for how one defines the juvenile or the adult criminal distinction. But as part of the raise the age process, which Vermont has been instituting for 7 years now, since 2018, that was when the legislation first passed. And then as of 2020 was when 18-year-olds first got brought into the family division as juveniles. So in other words, one of those non-big 14 offenses, if it's committed by, at that time, prior to 2020, if it had been committed by an 18-year-old, it'd be a criminal proceeding it'd be adult proceeding in the criminal division. But as of July 1st, 2020, 18-year-olds who committed one of these non-Big 14 offenses, they go into the family division. So if it's a misdemeanor or a felony that's not on that list, that starts in the family division. And that was step one of what's known as raise the age. Step two of raise the age is not in effect yet, but the proposed step two, when they first passed the bill back in 2018, was to also have 19-year-olds going to the family division. That was originally supposed to go into effect in 2022. It's been delayed a few times for various reasons over the years, the COVID pandemic, DCF staffing ability, various reasons. And so it's been pushed off, I think, 3 times now. And currently, it's scheduled to go into effect April 1st of this year. So a short time from now. April 1st, 2025 is where Act 125 that was passed last year set that date as, all right, this is when the 19-year-olds, step 2 of raise the age is going to take effect. So bit of background there. Second, just a quick, so as I said, so if it's not one of those Big 14 offenses, though, the family division has the ability to say, okay, for some children that are within their jurisdiction for some of these offenses, ordinarily you age out at age 18, right? But the family division can say, well, if you committed the offense at an older age, they have the authority to extend that jurisdiction by 6 months. The idea is that for 6 months longer, DCF could be able to supervise the kid, to have their case plan in effect, to have back and forth with the child's treatment plan. So that is in section 2 of the bill on page 2. And the proposal in H2 right now, you'll see under existing law, this is lines 8 through 11. So if the child is 16 or 17 when they commit the offense right now, the court can extend jurisdiction over the child for 6 months beyond the child's 19th birthday. So it gives them some extra time to have the case plan. The proposal is to add another year, go to their 20th birthday. So there's an extended period of time during which the family division can say, hey, we're going to have DCF continue their supervision over this child for not required, but it's not. Same thing, next line down. If the child is 18-year-olds at the time they committed it, they can extend it until 6 months past their 21st birthday under the proposal. Under current law, it's 6 months past their 20th. So that brings us to the next topic of the bill, which I just was describing, which is raise the age. Remember I said that right now, under current law, the 19-year-olds that raise the age step 2 would go into effect on April 1st. So that means if the legislature does nothing, doesn't pass any legislation, that goes into effect in 6 weeks, roughly. In 6 weeks, 19-year-olds who commit non-Big 14 offenses would start in the family division, not the criminal. So this proposal is to modify and to establish a further 2-year pause on that step 2 of raise the age. So 2 years. The 19-year-olds going into the family division under this proposal wouldn't happen until July 1st, 2027. All right. So if you just want to, so actually sections 3 and 4 on page 2, they strike the language that would go into effect in April 1st in a few weeks. And sections 5 through 9, I believe it is, reenact the age 19-year-old provisions and make them effective in 2027. So if you took a moment, if you want to, if you look at the effective date section of the bill, at the very end, page 8, the very last effective date section, you will see, and a little drafting magic, we'd like to call this, the section 11B, this striking of the provisions that are supposed to go into effect on April 1st. Those provisions of this act go into effect on March 31st, 2025. That's 1 day before April 1st. That's intentional because that way the April 1st pieces never happen. They never go into effect. Like a time loop. Back, like another.
And the age changes take effect July 1, and then the raise the age part, the 2 years out to.
Exactly, that's subsection C, exactly, until 2027, the raise the age. So it's got that 2-year pause. And that's most of the substance. There's also, which you may be familiar to you, there's also a big report section that starts on page 6. This is actually almost identical to the report. As the legislature has paused, raised the age a few times over the years, they have simultaneously required DCF and or the Agency of Human Services to provide progress reports. because that was kind of the idea. Fine, we'll pause it, but we want to hear what steps are being taken. What's the status of implementing Raise the Age, trying to make the new effective date work. So that's what this is. Same thing that you had last year, very similar, I should say. Last year, the reporting was every 2 months, and this year it's not as frequent. If you look at page 6, line 2, for example, there's 2 reporting dates required, July 1st, 2026 and December 1st, 2026. So 2 reports to this committee being one of them, but a list of committees that will get that report on the progress being made toward implementation. There's an additional piece to the report. The one piece that wasn't in the report last year is at the bottom of page 7, subsection B. This is a piece that has to do with data from the Red Clover treatment facility. So it's asking for specifically how many youths utilize Red Clover, on a monthly and annual basis, how long they stay there, what are their treatment needs, racial and gender demographic data, and any other data deemed relevant by TCF. So that's an additional piece that wasn't in the report last year.
And so I'm just thinking out loud. So we do want information about utilization of Red Clover, but they also have some other shorter term. I guess they are shorter term. Well, I guess they're not really treatment facilities. I'm thinking of the sheriff's place, and I'm just sorry. I'm thinking out loud about whether or not that report should include the other programs that
The
they're
window
developing.
that's not open
Window
yet.
that's not open, yeah. So, okay, let's hear from the bill sponsor and reporter. Thank you, Eric. I appreciate that.
Yes, absolutely. And also, just until I go, I've got about 10 or 15 more minutes. If you're still talking, go. I may have to slip out.
That's okay. Thank you.
You bet.
Oh, okay, yeah.
I'm good. It feels good.
Are you sure? Okay. You're illuminated.
Nice.
You're just illuminated, yes. Okay, welcome. Thank you
Yes,
so
thank you.
much for being here and for the opportunity to take a look at this bill. And so maybe in layperson's language, even though you're an attorney too, you can give us sort of like the overarching policy intent behind the bill.
Martin Lalonde, representative from South Burlington, chair of the House Judiciary Committee. So the overarching point of this bill is that, we have depending on the age of individual commits a crime, they can go to family court where there's lots of protections of confidentiality, or they go to criminal court. It also depends on what offense there is. The idea there is that youth don't have the brain development, the impulse control, and also often make stupid decisions that are criminal. That's kind of one component of this, but it is the idea of having a criminal record can really destroy somebody's life for a very, very long time. And rather not have juveniles burdened with a criminal record, if they can be rehabilitated in another way, which is what family court does. It's not just about rehabilitation. It's also about accountability as well. So that's the concept generally for why we have a juvenile justice system. Why we have on the upside, the raising the age component of it is the recognition of brain science and impulsivity and not wanting mistakes made when you're 18, 19, or even 20 to really affect the rest of your life. So that's where the raise the age in a very summary fashion, why we have that. But I can tell you kind of what we heard about these different aspects of the bill and why the bill ended up where it is. And I can just really start with section 1. We learned from testimony that from Marshall Paul, really the main person, he's the juvenile defender, the chief juvenile defender for the Defender General's office, explained that the cases, and he's only had a handful of cases of 10 or 11-year-olds who were charged with an offense in family court. And in all of those cases, the child has been found to be incompetent to stand trial. Not able to really defend, be a part of their defense. So it's like, these are individuals who really shouldn't be tried. They should be helped, or they often can end up in the chin system And it can often be actually the parents that are the problem and not the children. So that's really one of the fundamental reasons why we really should raise that age. It's a question of whether 12 is even, high enough, but this was a recommendation from I'm not going to say what RDAP stands for fully, but it's the Racial Disparities Advisory Panel that recommended this, and they have community members and the Office of Racial Equity, Defender General's Office, Attorney General's Office, state's attorneys, et cetera. This was a unanimous recommendation. And we did not get any opposition on this either, including with the striking the murder component as well, for the reason I already mentioned from Marshall Paul, but also none of the witnesses knew of any case where there has been somebody under 12 charged with murder in Vermont. I mean, maybe there was a long time ago, but in the memory of all these individuals, they could not name a case where somebody was charged. So that's why we also removed that again, and that was unanimous support for removing that. The one issue that came up though was the Department of State's attorney did note that sometimes victims in these situations can have a little bit more involvement if it is in a delinquency case, as opposed to going to a CHINS case. That was presented to us. But again, this is from somebody who said they've never had the situation of somebody under 12 who's committed murder. So that's the reason for that one. The second section, the rationale for that is, so we were looking at one of the things, so we had the 2 days of testimony with the joint hearing. We took another, probably more than 2 days, several days, looking at raise the age and looking at these various issues and the versions of this bill. One of the things that we're trying to get at is accountability. And we're focusing on the 18 and 19-year-olds. But just generally, there's a kind of a gap in accountability. Under 18, DCF can take legal custody of an individual and make decisions as if they're a parent, including sending to a secure locked facility as well. 18 and 19, you don't have that same kind of legal custody. And there was really a question of, well, what kind of accountability can we give for the really hard cases, the individuals who are violating their probation, are not taking responsibility and not trying to, be rehabilitated. That's not that many individuals, but we really were trying to figure out the accountability there and how an individual could be taken into custody and held. And we pushed on that, and we had a couple different ways that we approached it, and it just didn't seem to work. And ultimately, one of the questions was whether DCF can take custody of somebody who's 18, 19. And we were initially told that they couldn't. And even if they could, they don't have a facility. But then we have an email from somebody at DCF that explains and points out all the various statutes where, in fact, they can take custody. There's still the issue that there's not a place to put an 18 or 19-year-old because Red Clover you can't use for that. But this section 2 does help a little bit because it gives an extra year for somebody who is in the custody of DCF, who has probation conditions. It gives another year where they are being managed by DCF and can fulfill their conditions. So that was the rationale for that. Now, the delay in the raise the age, I think probably the most controversial component of this, because there are many individuals who definitely want to see this go into effect on April 1st. But I thought we had very strong testimony for why that would be a mistake. I think that the testimony that really finally decided it for me was from Marshall Paul of the Defender General's Office, who deals with this, and he said we should do a delay. They're not ready to take this on. It's the endeavor, the initiative can fail if we proceed now, and was in favor of the delay that we had. We had some lukewarm testimony from a couple individuals, Amy Davenport and Susanna Davis. I think all these individuals very much support this, but understand going ahead, it would be problematic now. As the chair knows, we've been hearing about this in the Joint Justice Oversight Committee and every other month report, and really trying to push them to do what's necessary. And DCF seems to be trying, I mean, to get ready, but they are not ready. They don't have the personnel. They're having trouble getting personnel to handle their current caseload. So having an additional caseload is problematic. So that's one of the reasons why we decided, well, let's go ahead and postpone it till July of 2027. But we do want reporting in the interim, definitely to keep track of this, to see where they're going. So that's where we ended up.
Okay, thank you. So I'm just gonna turn to Representative Donahue because Representative Donahue is is our liaison with judiciary, but has also followed these issues very closely, just for any perspective that you might want to provide and any recommendation that you have about our committee action on this. So
Well, I think the one issue that would have been most substantive for us to be thinking about was the original proposed language that was giving DCF custody for 18-year-olds in these circumstances. And there were a lot of good reasons for it, but I thought we were going to have to really sort of drill down a little about what that meant. And I was very relieved for the update that in the newest version that's been struck because DCF can address what they need without a change in statute. So I think that kind of removes the one thing that was most relevant to our jurisdiction in terms of, the role of DCF and so forth. The rest of it is dealing with the existing raise the age, which is not so much our.
well, yeah, I mean, we
it's-
actually did address it in our budget recommendations last year around the additional positions that would be required in order to
If they were going to do
implement,
it,
if they were
right.
going to do it, right? And of course, they were not funded for those positions. And so
I'm sorry.
yeah, I was just gonna say, I appreciate the Judiciary's Committee's sort of reflection and recognizing that it's a policy that, the body has acted on and wants to act on and wants to implement, but also being pragmatic at the same time that even though we might be a bit frustrated that it's not happening in the timetable that we want to see it happen, it's better to not try to implement something without sufficient resources in play. So,
And it does relate to our discussion even today about the, red clover, the cost of development of that high end. And yet even red clover cannot currently take an 18-year-old, let alone a 19-year-old. So they really don't have a resource for kids that they are telling us absolutely need to be in some kind of a secure setting. Tiny minority, but still, there is no capacity for that in the DCF system.
so what we do on one of these sort of where we're not taking jurisdiction of the bill, so we're not going to take a formal vote on the bill, but because there are some jurisdictional areas in terms of the involvement of DCF that we would we'll take a straw poll on this, and then we'll report out the results of that straw poll. So I want to just check in with people to see if you have any further questions, either for Eric or Representative Lalonde, before we move to that. I was gonna say, it looks like Representative Bishop, then Representative Donahue.
One question directly to H2 and non-tangentially related. If the state has been unable to get ready to raise the age to 19 for a few years now, and I understand there are workforce challenges and the like, is there anything that can be done through this vehicle that could help the states, nudge the states, otherwise move them to ensure, if this remains the intent of the legislature, to have this now take effect 2 years from now, that would increase the likelihood that they're ready to do that in 2 years?
Probably not. Not in this bill. I think the reporting requirement so that we're staying, we're going to continue to require them to make progress. And if you look at all the requirements in the report, those are the things that need to be addressed to be ready. So essentially oversight through that reporting requirement is first. Certainly, it's more probably a funding issue than anything, and it's probably an issue of getting the facility in Virgins up and running. Although my understanding lately is that that's not going to help with 18 and 19-year-olds. So hopefully you all can find a place for 18-year-olds. I don't know if you've heard that, but we had testimony just recently that because of pushback from in Virgins that they're
We hadn't heard that. I don't.
they're relooking at whether in fact, it sounds like this is from Tyler Allen, and
Yeah.
it sounds like they've decided that it's not going to have a third unit for over 17-year-olds, 18, 19, whatever. Which can be, even under current law, could be 20 because you could have 20-year-olds who are still in the system.
Right.
But that's for you guys. So if you guys can figure out where to put 18,
That's
19,
development.
20-year-olds,
Thank you.
you're welcome. Yes, it was a development that we just, yes.
It's actually, it actually is they might be doing it because of the city of Virgins, but the reality is we brought this up at Joint Justice Oversight as well around that they had really no plan to distinguish a 12-year-old from a 19-year-old in this facility, which was bad planning from my perspective. So I'm actually, even though we haven't heard from them directly about that, I'm glad to hear it, except for that that puts into question this 2-year timeframe, to be honest. Unless they can move quicker on something than they are in Virgins or even down in Wyndham County, which has been a nightmare.
But I do believe that's your all jurisdiction.
Yes, we'll have to look at that. We'll have to ask some questions about that.
Yeah, it seems to me, and if this involves a whole spin into that whole complex tree of where things, seems to me is that it ends up with the potential to defeat part of the point of raise the age, because if the judge if there's a sense that this 18 or 19-year-old child, or even 17, may need at least a brief time in a secure facility, and there isn't one, then that would motivate them to transfer the case to adult court. Because if it's, as long as it's a felony, it can't be if it's a misdemeanor, but a felony, right? They can transfer it, so,
Yeah,
yeah, right.
that's another whole topic.
Okay.
I understand it, but because I'm looking at the time and I want to make sure that we can give Chair Lalonde a opportunity to know what we're going to.
I did have a quick question, and
Yes.
probably helpful
ahead.
for everyone, but my recollection, not rechecking it, is that the juvenile system currently, if you are found to be a CHINS, child in need of supervision, the DCF has the ability to then place you in appropriate non-home setting and so forth, depending on what your needs are. But you're not labeled as a delinquent act. So it doesn't tie the hands of DCF to do what's needed to do
The under 12s.
for the under 12s, just to verify that. Yeah.
Yeah, absolutely.
It doesn't change. Their ability to do what they think is right for a child who's in their jurisdiction doesn't change.
Correct.
Okay. Any other questions about this before we take a straw poll? All right, so I'd entertain, did you have a question?
I do. It's somewhat related to this, and that this tries to address when an individual child has the capacity, mental capacity, if you will, to commit a crime. Is there anything in our criminal code, either a crime or an enhancement, for an adult who utilizes a child in the commission of a crime?
I don't know the answer to that.
utilizing child, I don't know, but for,
I mean, that's just a phrase I came up with. I'm just.
you mean sort of a child?
Child.
Contributing to the delinquency of a child.
Yeah.
But if they're not doing a delinquent act, then you can't, well.
Yeah. That would be not germane to this
Yeah.
question.
Nice on the curiosity. I like the way you do that. I'm gonna use that more often in my committee. I think I need to do that more often.
Okay, so I would entertain a motion to, find this, favorable, this, it's so moved,
So moved.
okay?
Oh, I'm not. I may.
Well.
She does.
Yeah.
You're saying all of
And
us.
you, weren't here for most of the conversations.
No, but I know about it. I don't agree with, increasing the age.
Okay.
Okay.
So all those in, favor of the motion to, concur with, H2 as presented, please just raise your hand. 1, 2, 3, 4, 5, 6, 7. All those opposed? 2, okay, and 2 absent. Okay, thank you very much.
Thank you
for being
very
here.
much, Mom.
Appreciate it.
Thank you.
Okay, folks, so we don't have time now to return to budget. I have a 4:30 meeting. Are people able to be here at 8:15 tomorrow morning?
Yes.
8:15?
I could-
Just moved it up. It was
I did. It was
8:30. She
8:30.
just pulled a quick
That's a
one.
hard one. I guess so.
I can.
Yeah, I will try really hard.
Yeah.
I'm driving from an hour and a half
You're
away.
coming from-
And then I have to drive to Barry and drop Morella.
Okay, let's keep it at 8:30. Let's keep it at 8:30.
Okay. thank
Let's
you.
keep it at 8:30. I'm just trying to, anyways, 8:30 tomorrow, budget. And if any of you are working on documents that you haven't gotten to me yet, I need them.